Okay. Good evening, everyone. I am Leila Zonouzi, President of Iranian Students of California, and we are beyond thrilled that you could join us at in this event. And this is our first transnational event, as we have people logging from all across California, the US, and Iran. So thank you for being interested in our events. Your presence really make our efforts worthwhile. This will be an informative session on the recent changes to U.S. immigration laws, and more specifically, the National Interest Waiver. The changes with and these this event will be we'll be joining with immigration lawyer Thomas J. Arkell. I would like to invite you all to submit your questions in the Q&A section addressed to all panelists or myself. But before we begin, I would like to say a few words about our organization, Iranian Students of California, ISC. So in November 2019, 9 Iranian student organizations came together and began laying the foundations for the Iranian Students of California. We sought to create an organization that would serve as a support group for new Iranian students who recently migrated to the US and Iranian students of Iranian heritage in California. We wish to serve as a bridge between the many generations within our community and be a connector for Iranian students across California. So ISC is an independent, voluntary, nonpartisan, religiously unaffiliated, collaborative coalition among 13 Iranian student organizations and growing across California who have came together to connect students of Iranian heritage across the state through community building, advocacy, and mentorship. Currently, we have brought together graduate students and undergraduate organizations at University of San Francisco, Stanford University, University of Southern California, UC Berkeley, UC Santa Cruz, UC Davis, UC Santa Barbara, UCLA, UC Riverside, UC Irvine, and Cal Poly San Luis Obispo. We wish to create a deeper integration of Iranian students with the Iranian community in the US, and we strive to be a thriving student-led organization focused on the betterment of academic, professional, social, and cultural experiences of Iranian students in California. Without further ado, I would like to introduce our speaker tonight, Mr. Thomas J. Arkell. He is a partner at Dunn Law Firm, founded in 1915 in Illinois. He exclusively practices immigration law, and for over 20 decades, he has represented international faculty members, researchers, scientists, physicians, high-profile professionals, and amateur athletes and sports teams with complicated immigration matters. Mr. Arkell, thank you for joining us.
Thank you very much for having me and for the introduction, Leila. It's a privilege to be able to try and help the Iranian students in California, and I'd like to thank your newly formed organization, the Iranian Students of California. Thank you, Leila and Saeed from USC, for putting this presentation together, and hopefully the information I can provide everybody is helpful. There's a lot been changing recently. I know that you mentioned to me before we started here today that you saw a similar presentation that I gave through USC, and this presentation is going to be quite a bit different because a lot has changed just in the last month. So the goal today is to provide as much information as I can, helpful information to everybody who's participating about recent developments, about some things that people might not be aware of that can maybe help overcome some of the obstacles that have been put in place recently for Iranian students. And then I will also go through the national interest waiver process, and I will answer any questions that people have at the end of the presentation. Stacy Rankenberger, my immigration practice manager, is also here with me, and she worked at Caterpillar for over a decade before working with me. She worked in immigration law exclusively. I was originally from Canada, international student. A lot of people think Canada doesn't really count when it comes to international students, but I was issued an F1 I was issued F1 student status, issued an I-20. I was stopped at the border when I crossed and questioned. I've been through the green card process. I've been questioned there. I also have represented many clients at green card interviews, became a US citizen. So I've gone through the immigration process. I was an international student at Notre Dame, earned my law degree from the University of Notre Dame, and I've been practicing immigration law exclusively for 23 years. And there have been a lot of changes, as I said, recently, and I'm going to touch on some of those right off the bat in case some people have to leave the presentation early. The first thing, some of the recent developments, screens being shared here, is that there's now a change for students that instead of the duration of status, and this is a proposed change, it's supposed to go into effect potentially on October the 26th, but I'll get into it. Instead of duration of status, there's a 4-year or a 2-year admission instead of duration of status, and it's 2 years proposed for Iranians in F and J status. And that's something that I'll get into in more detail, but there's a comment period through October the 26th. I'll provide information to everyone as far as what you can do to provide comments. And I've got a lot of Iranian friends. I've given presentations in person. Quite frankly, I like to give presentations to an auditorium full of people rather than sitting in a chair in an office. But I met a lot of good people from Iran. I've had dinners and lunches all across the country. I've attended the Yalda night and mediated a discussion between Iranians about Fest in June and whether it should be sweet or sour. But the Iranian community, I'm glad this organization has come together, needs to unite with regard to this specific proposal, because it's going to be very detrimental to the Iranian community. 2-year limitation is going to be very difficult for many reasons, which I'll get into, but that's one recent development that I'll touch on. Proposed increase in US filing fees. There was a significant proposed increase in USCIS filing fees that's been suspended due to an injunction. There's been a significant prevailing wage increase for H-1Bs, so it's going to be a little bit more difficult for individuals to go through the H-1B and permanent residence process when sponsored by an employer. I represent a large number of universities, and we've already found this to become an issue when preparing H-1B petitions and applications for labor certification for tenure track and non-tenure track faculty, as well as staff positions at universities. And that's why the national interest waiver is something that I'll discuss, where the prevailing wages is not an issue. And it's a good option for F1 students and J1 research scholars. The H-1B premium processing fee has increased from $1,440 to $2,500 effective October the 19th. So that's become more of an issue for employers. The good news is that premium processing will soon be available for NIW petitions, as well as some other petitions that I'll touch on. The date-specific admission of F and J non-immigrants, which I briefly touched on, the proposal. Again, it's Iran is subject to a 2-year limit instead of the 4-year limit that is going to be for many other countries. The 2-year limit is also for other countries that have a problem with overstays, more than 10%, but Iran does not have that problem. So it's something where international students from Iran, I think, both individually and through your institution, as well as through organizations like this, need to comment on this proposal and voice your position on it. And I'll provide you with information how to do so. But again, it's only 2 years. And as far as the commenting, I'll provide you with information. We can send an email out that you can share as far as the public comment. But for the, it's www.regulations.gov. You can insert ICEB-2019-006 in the search box, and then you can click comment now. Again, I'll send this so you have it, but it's something that as many people from Iran need to be as active as possible. A lot of people think, and I've had this conversation with many of my clients from Iran, that because you're an international student, even because you're a permanent resident, you may not be able to vote, but you have a voice. You have a voice, you can provide your public comments. And even if you are a permanent resident or a citizen, it's, I think, imperative for you to be involved and to, on behalf of people maybe who are in Iran who want to come and study here, or people who are already here who this may adversely affect, get involved and have your voice be heard both individually and collectively. For some specific information, I'm just going to provide this, go through this quite quickly, but instead of being admitted for duration of status, Fs and Js would be only admitted until the program end date. That's noted on the I-20 or DS 2019, not to exceed 4 years, unless, for example, again, for Iranian students, a period of 30 days following the 2-year end date of their admission. F and J seeking a program extension will continue to first request such an extension through the university. And then the F or J the F or J student or research scholar must timely apply for an extension of stay on Form I-539 with USCIS to remain in the US beyond the status expiration date on their I-94. So this is a change where now F and J students seeking a program extension, you'll go to the university, but you'll also have to file Form I-539, which has usually been filed for an extension of stay, for example, for an H-4 or a change of status. And so this I-539 will then need to be filed, and it will need to be filed with a corresponding filing fee. The transition provision, there's a transition provision in this proposal. So F and Js who are in the US for duration of status on the future effective date of the final rule would expire on the program end date not to exceed a period of 4 years from the final rule's effective date, plus an additional period of 60 days for Fs and 30 days for J non-immigrants. So there's going to be a transition provision for people who are already here. And what I often tell people is I'm going through this fairly quickly because it's a proposal, it's not law. Again, you'll want to comment, but I always try and tell international students in F and J status, if there's a provision that affects you, if there's a law or regulation that affects your F or J status, it's something you should talk to your international office about. You don't need to hire a lawyer to get advice on F or J issues. In my opinion, you might be getting ripped off if a lawyer is charging you to talk about issues related to your I-20 or DS 2019. You can get that information from your international office, and your international office, if this does become a law, will be well versed in these rules, and you'll want to talk to your international office about these rules as well. Extension of stay. So the period of extension of stay, again, must be filed on the I-539 and may be granted for the period of time needed to complete the program or the requested practical training not to exceed 4 years or more limited period of admission, for example, 2 years. That applies to Iranian students. Biometrics, so under this proposal, F and J applicants would be required to submit biometrics. Biometrics are fingerprints and photographs. Usually this was limited to applications for permanent residents. Then it got added for H-4 change of status. And now this may become into play where individuals who are filing for an extension of stay in F or J status may have to also file the I-539 and have their fingerprints and photographs taken. Also, for extensions, applicants will have to submit evidence of sufficient funds to cover their expenses. And failure to do so may result in ineligibility for the extension of stay. Interviews, there may be interviews for people in F and J status. F and 2 dependents would also need to file an I-539. If the dependents file their own 539, there'd be a separate fee. If the dependent files an I-539 as part of the applicant's extension of stay on the I-539, only one fee would be required. And as far as extensions that are pending, Fs would receive an automatic extension. And while their extension is pending, they would be an authorized period of stay. And I'm firing through this part quite quickly because it is a proposal, but it's something that people need to be aware of if it becomes effective. Post-completion OPT, so the number of days the applicants have to file prior to the program end date, that would increase from 90 to 120 days. But the number of days students have to file an application for post-completion OPT after the program end date, that would decrease from 60 to 30 days. Students applying for F1 post-completion OPT and STEM OPT would also have to file an application to extend their stay under the proposal. An F student whose I-94 will expire before the end date of the post-completion OPT they will have to file an I-765 for work authorization, as well as file the I-539 for extension of stay. Employment filing dates. The F1 student applying for standard OPT, they cannot begin in OPT until the extension request is approved and the employment authorization document is issued. As I'll talk about here briefly, there will be premium processing for certain change of status and extension applications, which may expedite these applications, but also end up costing people more money. And timely filed STEM OPT extensions would permit F1 students to work for up to 180 days beyond the expiration date of the standard post-completion OPT, while the STEM OPT I-765 and I-539 are pending. So if there's an extension that's filed, people can continue to work for up to 180 days. Another thing that's changed recently is that the prevailing wages for H-1Bs and applications for permanent residents that go through labor certification, so perm special handling cases, which are they're referred to previously as perm special handling, but for tenure track faculty positions where the employer has to show that the faculty member is the most qualified applicant for the position, or for non-faculty or professional positions that there are no qualified U.S. workers. The prevailing wage the employer has to pay has gone up significantly. This has caused a lot of issues with the higher education community. As I mentioned, I represent a number of universities, and there have been lawsuits filed. A lawsuit was filed in California. Stanford and Caltech are among the plaintiffs. One of the things that's come up in that lawsuit is there was an example used by the University of Utah, which is also a plaintiff, and there's a computer science professor. The prevailing wage previously was $68,000, and it's gone up to $200,000, and that's something that universities can't pay. So that's why this litigation has been filed, and there's also been litigation filed by Purdue University in the U.S. District Court. University of Michigan and Indiana University are among the plaintiffs there. And this just came out yesterday. I believe the lawsuits were filed. So all these things are happening very quickly. But the good news is that organizations like the American Immigration Lawyers Association are fighting these rules that are being enacted very quickly. Premium processing, there's some good news that on October 1, there was a law that was signed which allows for premium processing for EB1, EB2, and EB3, which includes NIW petitions. So in the past, there was no premium processing for NIW or national interest waiver petitions. Those fees have not been set or established yet for NIWs. but they should be implemented, I think, relatively soon, because the premium processing was announced, the increase in fees on October the 6th and was implemented October 9th. So that should be coming, which should be a positive for individuals in the Iranian community for national interest waivers. And I'll get into that shortly, why that's important. Change of status from F or J, that will also be available for premium processing, not greater than 1,750 days and not greater than 30-day time period. And for individuals seeking to change their status as a dependent in HRO or extend the status, that fee will be set not greater than 1,750 and required processing time frame not greater than 30 days. So that's another, I guess, positive, expensive, but a positive development from the standpoint of there'll be potential options to expedite cases and get an answer faster than the 6 months that it often takes for these types of cases. And I'll pass on a joke that I was going to state because of the political ramifications of it, but oftentimes, and actually I'm not going to pass on it, oftentimes in other countries where you pay the government more money to get something done more quickly, they have a different word for that, and it's called bribery. But in the US, if you pay the government more money to get something done in a timely manner, we refer to it as premium processing. The thing about premium processing is if you pay more money, it does work. You get an answer faster. You can communicate with a human being who's more in tune with what's happening with your case. So it is effective. It obviously just costs more money. I guess the bottom line is that, and again, for NIWs, it's going to be a very positive development because it'll be possible to expedite the change of status petitions, applications for employment authorization, and national interest waiver petitions. Also, there are options to file for H's and O's as well for premium processing. But the key for the people who are tuned in today probably are the national interest waiver petitions, because the national interest waiver petitions are opportunities for individuals to self-petition for a green card. And I'll get into that here shortly. So for the people who are not familiar with the national interest waiver, these are some of the benefits for a national interest waiver. It's a shortcut for permanent residents from the sense that you don't have to go through labor certification where an employer has to re-advertise your position and prove there are no qualified U.S. workers for the position. It doesn't require a prevailing wage. It can offer the opportunity, if somebody is sufficiently qualified, to file an adjustment of status application to adjust your status from an F or a J to a permanent resident. And if, while your adjustment of status is pending, you can obtain an advanced parole or temporary travel document, usually in about 6 months, which will allow you to travel in and out of the country and avoid the single entry issues that often trouble Iranian students. Also the visa suspension that has caused issues for people who are in H-1B status, for example, and also the travel ban issues that are causing issues for people who are from Iran and, for example, again, in H-1B status. So again, the premium processing will help with this, but the key is with the increase in filing fees, with the increase in prevailing wages, the national interest waiver is a good option, and there's a website there, nationalinterestwaivers.com, where you can learn more about it. We have an FAQ section, but I'll get into some detail here and again answer questions that anybody has. But as far as the details of it, these are the criteria for a national interest waiver. The proposed endeavor has to have both substantial merit and national importance. The key there is it has to be in the national interest of the United States. And most things that people who are PhD students or postdocs, for example, do are in the national interest. The petitioner, the individual, has to be well positioned to advance the proposed endeavor. And so what does that mean? Often it means if you're a researcher, that you're fairly highly cited, or that people are relying upon your work, whether you have a patent or if you're entrepreneurial, that there's people who are willing to fund your research, whether it's through venture capital funding or other funding. And these things are important to show that you're well positioned to advance the proposed endeavor. Again, citations, they look at how many times you've been cited according to Google Scholar, for example. They'll look at letters of recommendation or letters of support. They'll look at whether you've served as a reviewer sometimes is relevant. And again, whether you've had patents or whether you have secured funding or grants are important for individuals maybe who haven't been cited as frequently. The third, on balance, it would be beneficial to the United States to waive the job offer and labor certification requirements. Here, looking at what is your future plan? What is your plan for the future? Are you going to continue to do work that's in the national interest? Here, sometimes it comes up where people who are in academia, who are maybe PhD students or postdocs, get an opportunity to go into the private sector. The job title, the job duties are fairly important there, because if you're going to work for a company, you have a generic job title or job description, then that could cause problems for you potentially at your interview. And now with COVID, not everyone was interviewed, but now interviews are starting up again, so that almost all people who go through the green card process are interviewed by USCIS. Are you qualified? Are you qualified for a national interest waiver? How many citations do you need? Well, there's no magic number for citations. I've had many people who have been approved without any citations. It depends on what you do. For a researcher, it's very helpful to have citations. Usually I like to see at least 10 independent citations. I just had a case approved for somebody from Iran who had 7 and somebody else who had 5. But it's not always just about citations, because sometimes you'll get an officer who's a challenging officer, and you may have a lot of citations, but that officer may issue a request for evidence just because that's the officer you received. But the individual from Iran who just was approved with 7 citations did not get any request for evidence. And so it's difficult to predict. That's why we will review your CV. If you want to send your CV and your Google Scholar profile to stacy@dunlaw.com, we'll review it at no charge to let you know if we think that you would be qualified. But they'll look at citations, as I mentioned. They'll look at service as a reviewer. They will look at patents. They will look at journals. They'll look at the impact factor of journals. They'll look at presentations. They'll look at possibly your Publons profile if you've served as a reviewer. All of those things are somewhat relevant to it. But if you're entrepreneurial, again, they'll look at funding. I do a lot of work for companies who are involved with research parks, or companies that are affiliated with universities. Maybe I'm working on 2 cases right now where professors have started their own companies. They have people who are working there. They've received funding from venture capital, or even through an institution. And how much is the funding? How much is it valued at? Is an individual receiving funding through the university because of the value of a patent? All of those things are somewhat relevant. How many letters of recommendation do you need? I usually like to see between 4 and 6, usually 6. Recommendation letters, I get the question often, should they be dependent, independent? It can be a mix, but USCIS gives more weight to independent letters of recommendation, which are deemed to be individuals who are outside of your circle of colleagues and collaborators, generally people who are not listed on your CV. Do we help with recommendation letters? Yes, we work collaboratively with our clients to draft recommendation letters, and we will also draft the recommendation letters for our clients if that's their choice. Is a job offer required for an NIW petition? The answer to that is no, it's not required. And we've had many cases filed and approved for PhD students who are still PhD students and received a green card before they graduated. But it's definitely helpful if there's a job offer because that will help show your future plan. Can you apply from F1 or OPT status? Yes, you can. Whether you should apply is another issue because you should only apply if you're qualified. I don't want my clients to waste their money, and I don't want to take a case generally that I don't think has a high probability of success because that's not good for my clients, nor is it good for me. But is it possible? Yes, it is. But again, you only want to do it if probably you have a strong case. And that's again where I'd be happy to evaluate your credentials. How can you do it? Again, you can email your Google Scholar and your CV to stacy@dunnlaw.com, and that's at the bottom of the screen, stacy@dunnlaw.com. How much does it cost? We're very transparent about how much it costs. That's what we charge. It's $3,900. It's 4 payments of $975 or 9 monthly payments. We can pay you because I realize that students and postdocs often don't have a lot of spare money. You've got rent to pay, and I know everything in California is expensive. I actually just had a daughter who graduated from college in California. I know it's expensive to live out there. I was a student too myself at one point in time and didn't have any money, so I realized that it's a challenge financially, and especially with USCIS filing fees going up. So we offer payment plans. You can pay by credit card, and we don't charge any additional processing fee to pay by credit card. And we don't charge for RFEs or copies. We try to provide a flat fee because I know when I'm a consumer, I don't like hidden fees, and we try to be transparent with our clients as well. One thing is that we're having people file relatively soon now because the filing fees were going to go way up. They're going to charge for EAD and advanced parole or I-765 and I-131 applications in addition to the adjustment of status. So we're filing as many cases as we can right now before the filing fees go up for people who are qualified. The good news too for people is that good NIW cases are still getting approved. We're getting approvals in on a daily basis, and we're trying to update our website to provide approvals and copies of approval notice, but candidly, we just had 6 this week for clients from Iran approvals for NIWs, so they are coming in and they're getting approved. But this month has been quite hectic, so we're more concerned about getting our cases filed than we are with updating our website. But again, there's the website. There's the phone number to the firm, and then Stacy's email address, and happy to answer any questions that anybody has right now. So the first question that I'm seeing is that, is it possible to request premium processing? It's actually the second question, but I'll go back to the first question. Is it possible to request premium processing only for I-45 petitions? So the short answer to that right now is no. There's no premium processing for an I-45 application at the present time. Another question that I had is, if you consult with a lawyer about the chances for success under an NIW, will this affect your application for another visa like a J1? Because will the government have access to that? So the answer to that is no. So if I have somebody consult with me about their chances for a national interest waiver, then that is between me and the prospective individual. I'm not going to share that with the U.S. government. That's between you as a prospective client and myself. And I'll often, even when I have people who are clients, I'll often say, oh, I know you're working with my friend, but I can't tell anybody else about what's happening with anybody else's case because of confidentiality, and we take that very seriously. How much does premium processing for the NIW cost? So right now, they haven't set that, but it's not to exceed, I believe it was $2,500 is the max that can be charged for the new premium processing. And so a case that's pending right now for an NIW, it may be possible once this is implemented for us to interfile for premium processing so that we get an answer faster. That's the case right now with H-1Bs, for example. If a case is pending and the client wants to upgrade to premium processing, we can then file the request for premium processing to get an answer faster. What does the questions are coming in fast and furious here, so we'll do our best to rattle through them. What does independent citation mean? Is citation by the research group or lab I work for or the students of my graduate study supervisor counted? So a pure independent citation is from someone who is outside of your research group. But clearly, if you cite yourself, it's not an independent citation. It's more of a gray area if it's somebody who's in your group, but it's clearly not a pure independent citation from somebody who does not work with you or is affiliated with you. The same thing with letters of recommendation, USCIS knows that generally somebody you work with down the hallway will sign a strong letter for you, whereas it's more difficult to get somebody who you've never worked with or collaborated with. Should letters of recommendation be from someone inside the US or foreign recommenders acceptable too? I prefer to get letters from people who are inside the United States because what we're trying to prove is that the work that you do is in the national interest of the United States. Could you explain whether an entrepreneur with no publications can apply for an NIW? The answer is yes, and I've done many entrepreneur cases successfully. I've actually done entrepreneur cases. I've done many pilot cases successfully. Some out in California actually just got a case approved for a pilot who was transporting in the heart of the COVID crisis in New York City, COVID patients and unfortunately bodies on an expedited matter. Very well-trained pilot out in California who's helping fight forest fires. But entrepreneurs, somebody who's working on project in New York City, Manhattan, with agriculture because of food deserts. So they're very interesting things. I've gotten many cases approved for people who are entrepreneurs who have no publications, no citations. But again, you have to show that there's an economic value to your work. Does Senate Bill S-36 going on in the Senate affect the NIW petitions? As of right now, no. So those who don't know, the Senate Bill 386 is something that is not going forward right now. I know there's been a lot of talk about that in the Iranian community. I've given presentations in California, USC, Massachusetts, at Harvard, at Penn State, in Ohio, all over the country. And that comes up every time. Again, usually I'm giving a presentation to an auditorium full of people, which is probably why I'm using my hands all the time. And I prefer that more than sitting in a chair in a Zoom presentation. I like the interactive piece of working with my clients from Iran, but this is what we have right now. But 386, right now, it's not moving forward. Could that change? It could change. And if it does, obviously, it will slow everything down for individuals from Iran to get permanent residence because individuals from India will be put into the same pool. So right now, there's nothing going on, but I can't predict what will happen in the future. I'm reading through some of these because I know we're running short on time. So some of these are F related questions and J related questions. I would direct people to your international office. And so a lot of the questions here that I'm seeing are related to F and J's. So I don't know if there's, okay. Will it be possible? Will it be possible to request premium process for cases filed before the date of availability of permanent residence? So I believe that question is asking, so if you have a pending case, can you file for premium processing? In the past, you've been able to, and I'm assuming, anticipating that that will be the case for this premium processing as well. Should the recommender be in the same field of research as me? The short answer is yes, because you want somebody who's qualified to be able to make attestations or statements regarding your qualifications. I've heard that due to the travel ban, Iranians getting approved from outside US cannot get immigrant visas, so cannot land to get the green card. Is that right? It's a very good question, and there's been many good questions, but so I have clients who are in Iran, and I know there's some people who might be listening or watching from Iran, and I've been able to obtain approvals for people from Iran, and I've also been able to obtain waivers of the travel ban for people from Iran. And one of the benefits of the national interest waiver is if the national interest waiver is approved, then the government has decided that what you do is in the national interest. And that's one of the things that the government considers when you're applying for a travel ban. So can I guarantee that if a national interest waiver petition gets approved that someone will also get a waiver of the travel ban? No, I cannot. I can say that I have had success with clients who were in Iran when we filed, whose national interest waiver was approved while they're in Iran, who were able to obtain a waiver of the travel ban with my assistance, and who are now here with their families. But so it is possible, but of course it's challenging. What is the minimum amount of investment for startups founders to be eligible for an NIW? That's something where I want to see a business plan for somebody and to see what the plan is and whether it'd be viable. And there's a question on here that I've answered, but I'm going to just go and address something else I think that probably needs to be addressed, is that with some of the changes that are happening in immigration, there are, it's become more challenging in that USCIS is scrutinizing petitions that people are going to be interviewed. And so it's probably more important now than ever that petitions are prepared in a professional way and to increase your probability of success. And the thing that I'm seeing a lot is that good cases are still getting approved, but they have to be prepared professionally. And now more than ever, I think that people need interpersonal professional service, that it's more challenging to be just a number, one of many people who don't get personalized attention in this environment, because it's a challenging time. You've got also, we haven't touched on it, that there are public charge issues. So when you apply for your adjustment of status, have you ever received any type of government funding? Those things come up on a new form that's called an I-944. When you come into the country, social media. Now when you come into the country, the government can ask for your social media accounts and check those. Those are important things. So now more than ever, it's important that you get probably professional help to address these issues. I'm on the phone a lot now with people's Zoom calls or calls, because of questions they have that are coming in. What political organizations or groups have you been a member of? Those things come up at your interview. These are things that I think that people often overlook. They think, well, I can just do it myself, or I can file with this group who files all these cases, but you don't ever get to talk to the attorney or person who's handling your case. Those things now, I think more than ever, are becoming an issue for clients who aren't getting personalized help, because at the end of the day, you're going to have to go through the entire process and get interviewed, and you need to be able to address some of these issues. And while you're going through your case, there are more issues with adjudicators now, processing change of status applications, NIW petitions, adjustment status applications. So those things are just letting people know are important. So for citations, I'm getting questions about citations. So our citations, all citations on Google Scholar are considered, but just like there's different types of publications that have different impact factors and are more well regarded, the citations to survey papers or other papers maybe aren't given the same weight as independent citations to peer-reviewed journal papers. Somebody asked the question that I'm just going to paraphrase this question, but that it's helpful for somebody to be on active projects on their CV when applying under the national interest waiver category. And I would say generally that's the case, that if you don't have anything that's recent on your CV, that's not necessarily going to be helpful. But I just filed a case for somebody who, and it's actually an EB1A extraordinary ability case for somebody who doesn't have a lot recently on their CV with publications, but they were part of a major university's research. They're part of a patent, and that research was provided funding by a private company in excess of $3 million, and this person's portion of that was in excess of $100,000. So those things also factor in, but they have to be fleshed out and they have to be documented and researched in the petition. So somebody has asked the question that they graduated with a double major and they're on OPT. Should their documents be related to only one of the degrees, or are the citations counted in both degrees altogether? So citations are counted collectively, but if you have multiple degrees, or if you're a multidisciplinary researcher, either that needs to be emphasized, or if you've completely changed fields, then maybe the focus needs to be on your current field. You can discuss the previous research and how that has helped you with your current research, but you're going to need to have a focus. And I get a lot of these cases with multidisciplinary researchers. They're a little bit more challenging and require a little bit more lawyering, but they also can get approved because it helps to show that you're unique, usually with your skill set.
All right, Mr. Arkell. There are a lot of questions about if this new proposed law that might go into effect in October affects students that are currently in the US. If you could just say a few words about that, that would be great too. Thanks.
Sure. So the short answer is yes, it does. It would, if it goes through, it would affect people who are already here. And so again, I'll send an email to you, Layla, and you can circulate it to everybody who attended today about how they can provide public comments. And again, I say this because, like I said, I've got some friends, many friends from all over the country from Iran, many people started out as clients and I now consider friends. And one of the conversations I had is that one individual told me that a lot of people from Iran do things on their own, and they don't often come together to, which is why this type of community is great. And you're laughing, so I guess there must be some truth to that. But I think it's really imperative and important for Iranians to unite around, especially something like this, because it's going to have a huge effect on your community and not a positive effect. And so you need to have your voices heard individually, through your own institutions, collectively through this group in California with all Iranian students. Comment, make your voice heard, unite with each other. Even if it doesn't personally affect you, it's going to affect people you know, their friends, their relatives. So people need to do something about it, and they need to do something about it, not just individually, not just collectively. And I joke sometimes that some people need to, instead of just having their head down in their lab and working really hard on a research project that is consuming their life, look at the big picture for their future. Look at, okay, how am I going to get a green card? How am I going to become a permanent resident? If I file under the NIW category, okay, I can get my own travel document, my own work card. I can get a green card. I can control my own future. I can be eligible for more grants. I can pass background checks. Those things, look at it for yourself, but then also look at things like this for the whole community about how is this going to affect everybody. And yes, you need to look out for your own future and that, but you also need to take some consideration to your group as a whole, which is why I think it's great that you've put this organization together and that you're putting things like this on. Hopefully I answered your question, but again, we'll send you this information about the proposal. If it looks like it's going to go through, and a public comment is open only until October the 26th. If it looks like it's going to go through, then you'll want to talk to your international office too about it, voice your concerns to them, and also get information from them what you need to do as far as your situation to make sure that it doesn't cause particular problems for you and that you file a timely extension of stay or application for optional practical training.
Thank you so much. I think we only have time for maybe one or two questions.
Okay, so does applying for NIW and change of status, I'm assuming that means adjustment of status, does applying for NIW and adjustment of status during the PhD time impact the chance of getting approved for OPT after the graduation? So generally, people have not had an issue, at least my clients haven't, with filing the NIW while they're in F1 student status, but I suggest to them, if they're concerned about it, to talk to the international office about it. But if you file an I-45 adjustment of status, you've shown an immigrant intent. And so if you file that I-45, then you're probably going to have difficulty getting, say, for example, an OPT STEM extension. So a lot of times with international students, if you're really qualified, then you may want to file the NIW and adjustment of status concurrently. If you're getting close to getting your OPT, you may want to wait until you have your OPT in hand before filing the NIW and adjustment of status to reduce some of that risk, so that you at least have that 1 year in OPT or 2 years with the OPT STEM extension. And here, do you want me to answer one more?
Yes, please.
Okay, all right. So the question was, what about research or paper which is featured on the news or NIH website? Does that count in writing the petition for the NIW? So yes, positive media attention helps. And I would say media attention primarily that is national or international, as opposed to through your institution or local. It's going to have more effect if it's national or international in scope. But yes, media does help in addition to citations, strong letters of recommendation, and other supporting documentation. So hopefully all this information was helpful to everybody who participated. And I hope everybody stays well. That it sounds like the weather's cooling down in California, which is good. Hopefully the forest fires subside. But again, I appreciate the opportunity this evening, and I hope it was helpful to everybody.
Thank you so much. I really appreciate you spending your time with us. And we had a very exciting and lively attendees. So hopefully we can do this again with
Right, it'd be my pleasure
really
to
more
help out.
immigration questions.
Yeah, it'd be my pleasure to help out in any way I can and maybe answer some of the other questions that came flooding in.
That would be great. And thank you to all our attendees. We really, really appreciate your support, and shoot us any questions or concerns you have, and we might be able to send them to Mr. Arkell. And
And again, if you want to send your CV and Google Scholar profile, we're happy to look at it, no charge. And again, we'll email you the information so people can make public comments on this proposal.
thank you so much.
Thank you. Take care.
Have a good night, everyone. Bye.
Bye.